Good evening. My name's Jacqui Brauman and I'm from TBA Law. I'm the owner and principal solicitor. And we have a webinar tonight. So this topic is naming legal guardians for minors. And this topic is one that's close to my heart and one of the main reasons why I became a specialist in wills and estate planning. So I had been a lawyer for about 7 years before I decided which area of the law I particularly wanted to do further study in. And when I get to the case study, I'll explain to you what case sort of pushed me along. But what I'm going to do is share my screen with you so you can see the slides, and I'll talk through the webinar. Any questions that you have, you can put into the chat box, and I'll come back to this screen and have a look at it towards the end. I won't be jumping backwards and forwards between screens. So when you think of the question, put it in. I may answer the question further as I go without having seen it, but I will come back to the questions at the end. So let me share my screen. So, as I said, today's webinar is naming legal guardians for minors. And in most cases where a couple doesn't have children, the law will take care of your estate under the laws of intestacy without you having a will, and it will be sufficient. However, if you have children, this is the main reason you should be doing a will, to name guardians for your children. And the secondary thing is to make sure the correct people are looking after the money for them, and that there's not a conflict of interest that exists between the guardian and the person looking after the money. So again, a little bit more about me. My name is Jacqui Brauman. I've been running TBA Law for about 7 years. Down the bottom left-hand corner there, that's a specialist accreditation logo which I got. As I said earlier, I'd been working as a lawyer for about 7 years. I decided I wanted to specialise in wills and estates, so I actually did my master's degree first, and then I applied to the Law Institute and I did a 12-month program with them to get this accreditation. So there's only about 80 of us in Victoria that have this accreditation, and I think there's about 12,000 lawyers all up in Victoria. And then in the other bottom corner, you can see that there's some of my passions. So I'm not just a lawyer, I am a human. That is my husband and my dog on our boat in Lake Eildon, fishing. So we do a whole lot of fishing, mainly ocean fishing, but it's always nice to get away. And so that's what we do most weekends if we can. Now, on to estate planning. So estate planning has come a long way in the last 50 years particularly, and mainly because it's been necessary. So there is always a lot of changes in laws and regulations, and some of them I think are probably unnecessary, and they're just creating more red tape or more public service jobs. But in the area of estate planning, people's assets have actually gotten more and more complex over the last 50 years. People are wealthier. People own more things. They don't just have a house and a bank account. They now have potentially a family trust. They may have investment properties. There's more people running more complex businesses. There's superannuation. And there's more and more people living longer, experiencing either a decline physically or mentally, which causes problems with needing powers of attorney, And then all sorts of medical regulation comes around that, particularly with medical treatment. So this poker chip image has a lot of the aspects that estate planning involves. So yes, wills are part of it, but also looking at what you own and how you own it. Enduring powers of attorney and the appointment of a medical treatment decision maker, as I said before, advanced healthcare directives, superannuation binding nominations because your will doesn't cover your super. Testamentary trusts are also quite often recommended by financial planners and accountants for asset protection and tax benefits. So if you're referred by another professional who wants you to have that done in your will, that's something that we do. Life insurance and total and permanent disability insurance are things that are happening more and more and should be in place, particularly where there's a lot of debt. Instructions for guardians are also important. Whilst you can appoint a guardian, instructions to your guardian are also important, which I'm going to be talking about today. Family trusts, as I said, need to be managed. The will usually doesn't cover those. There are powers in the family trust that need to be dealt with separately. And then, leaving instructions for your bits and pieces, your personal assets. And then people wanting more and more say about whether they're buried or cremated and what sort of service people have after they pass. Excuse me, I can just feel a bit of wafer in the back of my throat that I know is going to tickle me. All right, so having run through that fairly quickly, let's come back to the case study that I talked about or mentioned earlier as to the main reason why I went into the area of specialising in estate planning. And it's become a particular passion of mine to try and get people, parents who have young children, to do their estate planning. When it was about 5 or 6 years ago, and I had a friend at the time working in as a public prosecutor. So she was coming up to the sentencing of a woman that she prosecuted. This woman had driven straight through a red light and killed a couple. The woman driving hadn't been drinking or anything. It was just bad luck. So that couple had flown down from Sydney for the weekend to watch an AFL game. They were parents of young children. One was preschool age and the other was in primary school. And so they'd left the kids at home and they'd come down for a fun weekend together and inadvertently ended up being killed by a driver running red light. Tragic in itself that those children were orphaned. However, the parents didn't have wills. This was about 18 months after the couple had died that the woman was coming to be prosecuted. And victim impact statements had been done as part of the submissions for sentencing. Now, as part of those victim impact statements, my friend said that it had become apparent that those children had been in and out of family court for the last 18 months because the grandparents on either side of the family hated each other and wanted those children living with them. So they were fighting over those kids and over the control of the money. And that is certainly not, I think, what those parents would have wanted. I think those grandparents were behaving atrociously. And those kids' lives have been impacted greater than just by the death of their parents, because they are now having to be dragged through court. They have to balance the emotional feelings of each of their sets of grandparents, which is not something children should do. And so this was a case clearly that had affected me significantly enough that I thought that things really need to be addressed early in planning to prevent these sort of disputes arising. Now, a lot of lawyers make a lot of money out of will disputes, out of poorly drafted wills, and out of people who don't have wills. So it's part of my mission to really do those law firms out of work, because I think that it should be done correctly up front. So there you go. So, some mistakes that parents make. If they actually do wills and appoint guardians, there are some things that they quite regularly don't consider. And I'm going to flick over. You probably can't see this actually. So on my website, tbalaw.com.au, if you search in the little, press the little search function and just search guardians, you'll get a few blog articles come up. And one of them is called The 7 Errors Parents Make When Appointing Guardians for Their Children. So one of the main errors is that they base their decision on who they appoint on financial resources. Now, your appointment of a guardian shouldn't be based on money. I know that you're worried about a financial burden, but particularly these days, if you have real estate and you have superannuation, there's going to be a significant amount of money there for your children. If we do the will right, those funds will be held in trust for your children, with the ability for the guardian to access it for the education and upbringing of your children. So your guardian won't be out of pocket. And that's where I was brought up earlier, that we need to make sure the people looking after the money don't have a conflict of interest with the care of the children. So we want an independent person overseeing the looking after the money, so that the guardian doesn't just dip into the money whenever they feel the need, that it's actually used for the upbringing of your children. But there you go. You don't have to worry about the guardian being out of pocket. One of the other mistakes that parents often make is that they think that family members are the only appropriate guardians for their children. Now, if you've got a close family, then yeah, fair enough. But a lot of families are really spread out these days. So you might not even be close to where your parents or your siblings live. Or you just may not be close to them in terms of your values. You might now be very different from your family. So what you really need to be thinking about is who has the most similar values to us, who's most likely to keep the children in a routine that they're as familiar with as possible, and potentially those are close friends who live nearby you, who know your kids better than potentially their own grandparents do, and who are removed enough from your family to make sure that the kids maintain a relationship with their extended family. And look, I really think that whilst blood relatives may take on your kids as guardians under an obligation, I think that if you speak to your friends and you ask them, I think that most of the time they would be honoured that you're asking, and it will bring your relationship closer, and potentially the relationship between those friends of yours and your children as well, because they take more of an interest. So just something to think about. The other thing that parents often forget is that they probably need not only to name a primary guardian, but also an alternative just in case. So you may appoint someone and then their life changes and they may not be able to do it anymore, or they may not be around for whatever reason. So it is a good idea to have an alternative. And as part of that, another mistake that parents often make is to name two people in a couple as guardians jointly. rather than just naming the most important person. Now, if I made that mistake, I would name my best friend and her husband as guardians. However, if something happened to her, her husband is not the person that I would want bringing up my children. Also, if they separated, I'd want to make sure that those kids were with her and not had any joint custody arrangements. But the other thing is, I wouldn't want my children to experience a separation or a divorce between the people caring for them. So in that case, I may have an alternative appointed, which would be if my best friend couldn't care for them, was unable, or was going through a separation, then the next best person would step in. The other thing that parents often forget is to notify the people that they've named as guardians. So as I was saying before, if you're going to appoint friends, generally you have the conversation. But sometimes if you appoint your parents, you just assume that they're going to be okay with it. But look, realistically, they're approaching retirement. They may not want that burden. They've raised a set of kids already. They might not be able to say no to you. So you need to speak and have the conversation. But then also providing them with proper instructions is important. So this is also what I was talking about before. Providing instructions to guardians. So it's a separate document. It's not necessarily binding, or you can do your instructions in however way you want. You could do a video, you could speak to them, you could provide a recorded audio. But basically in the instructions, you want to talk about or give them some guidance on the important extracurricular activities you'd like your children to be involved in. Whether you, private or public education is important to you, how you want them to treat pocket money, how you want them to help with the first car or not, what you believe about punishment. All these sorts of things can be really important. So I think that that's a mistake that parents often gloss over. And one of the final things is that parents often make a mistake around is that you can exclude someone from being a guardian as well. If you're really worried about it, that someone's going to jump up and down and potentially challenge your guardianship appointment, do a separate document again outlining why you want to exclude them, because then that can be used as evidence in any dispute proceeding that they raise, right? So those are the common mistakes. So just to recap, basing your decisions on financial resources is one of the first mistakes. Second one is thinking family members are the only people or the main people that should be guardians. So I think people should think further abroad and think friends as well. So think more importantly about the values you hold and who's the closest to those. Third is not naming a backup. Fourth is naming a couple instead of just the main person that you want to. Fifth is not notifying the people that you're appointing and giving them proper instructions. And then the final one is not excluding a guardian if it's important to you that person not have any involvement with the care of your children. So, what to do? Well, when you're appointing a guardian, you make a will. That is where the guardian appointment is. The other thing to do is some form of guardian instruction. And more than likely a power of attorney as well, because a power of attorney can stand like a temporary guardianship in some ways. Because if you are in a car accident and cannot look after the children for a period of time, if you have someone who's appointed as a power of attorney and it specifically says they can maintain your dependence, then they will have some rights to be able to swoop in and make sure your kids are okay and prevent the state government from stepping in and putting them into foster care. So as part of all that, well, where do you start? And it's hard when you don't know where to start. So you may feel a bit overwhelmed with all the things to think about. You're really uncertain about the process and what is involved. It's all a bit hard and you're actually pretty exhausted because you've got a million other things to do. But once you start doing research, and this webinar is part of that, you're exploring what you need to do. You start feeling like you know where to go, that you know the importance, so you can't just let it go anymore. So you get started, you're feeling more proactive, and then by the time you've actually done your estate planning, you've got absolute certainty and control. Your kids are protected, your assets are protected, they'll go to the right place. So the process to do a family legacy plan with us, which involves usually a couple doing their wills, superannuation binding nominations, enduring powers of attorney, medical treatment appointments, instructions for guardians. It's a 5-step process, 2 appointments. The first appointment with us, we get all the information that we need from you. In between the 2 appointments, we draft everything for you. We send you the drafts. We get any extra information we need so that at the second appointment, you come back, we have everything signed. So this process takes about 2 to 4 weeks, and then your final plan is delivered. You're done. No more worrying. So what does it all cost? So on our website, we do have all our costs for our estate planning outlined there. If you didn't want to go ahead and do the full plan straight away because you've got a semi-plan done, we're quite happy to review your situation. The cost on here says that it's $450 for a review. If at that review you then proceeded to do your planning with us, that $450 rolls into your whole package. So we don't charge $450 plus the package fee. The other thing to note is that we have a special. That initial appointment for the family situation review is now $295. So if you contact our office and mention that you've watched the webinar, you'll get that initial appointment for $295. And just be aware that I'm usually booked out 2 weeks in advance and I move around to all different offices. So you'll have to get me in the right week at the right day. So do give a call because there's a limited amount of spaces and $295 won't last forever. So having said all that, I hope that you found out a whole lot of information that you didn't otherwise know. Really, and you realize the importance of doing your planning for your kids' sake. So I'm now going to stop that share and go back to the main screen and see how everyone is going. So hi, just checking in. What questions do we have? Right, looks like there's nothing in the chat box. So it looks like I may have answered things as I went. If you do have any questions, they can be emailed to me directly. My email address is jacqui@tbalaw.com.au, so quite simple. And I'll respond to you within 24 hours, so you'll have your answer. So, hope that was helpful. I hope you have a great evening. And again, please take advantage of that $295 and reach out to our office and make that appointment when you can. In the meantime, take care of yourself and your family.